Yeah, and that's what's that. I haven't really done murder or anything. Murder. Oh, I mean, I guess it would probably most likely fall under 701 because it's probably was the house. But you know, like the random. Yeah, like your VR case. Yeah. I'll touch it. It's surprising. I really don't want to. Sure. Yeah. I just looked it up.
Oh, can I have the microphone? Thank you. All right, everyone, good morning. I'm going to call the docket. They tell me today is Friday, so everybody should be having a great day because it's Friday. And then Monday is the day of celebration and marching. So I'm going to call the docket. Let me know you're here. If you're not here, I'm going to assume that you're not here and a warrant may be issued for your arrest. Everybody who's seated on the front row, that means that you're late. So if you don't want to be considered late, you should probably not be sitting on the front row. All right, Arturo Vara. Thank you. In custody, we have Angel Gonzalez, Daniel Flores.
Here.
In custody, we have Martin Rios, Michael. Thank you. We have in custody Michael Lucio, Julian Reyes, Yvonne Perez, Tanisha Allison. Thank you. How do you pronounce your first name? Tanisha. Okay. In custody, we have Michael Montoya, Benny Santos, Daniel Daron, Eric DeLamba. Thank you. In custody, we have Landaverti, Ashley Windrum. Thank you. In custody, we have Richard Whitney, Alvoid Todd. Am I pronouncing that first name correctly? Okay. Laura Botello. Jarrell Wilkerson. In custody, we have Jackson Youngblood, Robert Garcia, Mark Lewis, Michael Shoemaker. Thank you. Mario Medellin, Joshua Jackson, Igor Alinsky, Jeffrey Adames. Thank you. Guillermo Rodriguez, Kyle Adams, Jonathan Ramirez, Eddie Marine. In custody, we have Fabian Vega, Emmanuel Saldana, Xavier Griffin, Delania Stevens. Morning. Marciela Alonso. All right, is there anyone who's present and your name was not called? Yes, what's your name?
Mario Vega.
Do you have an attorney?
Yes.
Who's your attorney? All right, anyone else whose name was not called? All right, these are the rules of the court. To all the attorneys, if you have someone in custody, do not approach the court if your client has not been brought out. You need to confer with the state. You need to confer with your client. In this court, it's first come, first serve. So you see boxes on either side of the courtroom. Just grab your file, place it on the prosecutor's desk, have a seat. They will call you in the order of appearance. First will be first, last will be last. If you ask for your client to be brought up from the back by the deputy, do not leave because that slows down the process and it takes a lot for them to go downstairs and grab your client. So it's Friday. Let's keep it a happy Friday. Let's be kind to each other. Put some patience in your pocket. Take it out as needed, and we will get there at the end of the day. So everyone, please confer. All right, Xavier, are you able to hear me? Just give me the thumbs up if you can hear me. All right, so what I'm going to do is I'm going to put you in the waiting room. We're awaiting your attorney. As soon as your attorney zooms in, we'll bring you back in. So let the deputies know you're in the waiting room, but we're not done with you, okay?
Yeah, that's weird. Yes. They're supposed to. It's usually a certain baby.
All right, Deputy Laura. They are warning us that on January 13th, which is today, that there's going to be heavy traffic because the Spurs are playing. So is it really going to be so heavy that there's 60,000 people?
I heard this morning that they sold 65,000 tickets already.
Okay. Well, I tell you what, all the starters had better play.
Yeah, it's a 99. But just fill this out. If we can do agreement.
Yes, to avoid 281.
Yes, 281 and 37. Oh, and I thought about our discussion. And if zombies are not alive, technically, I don't know why swimming would be a problem. And wouldn't they just, if they sank, wouldn't they just be walking on the bottom? So, Dinah, I think you're incorrect about going, I'm going to live near the water, on the water. So you're thinking they can't get to your boat. That's, yeah.
That is right.
Yes, but here's the thing. If she goes on an all rig and the zombies walk there, they're just going to crawl and she's stuck.
How are they gonna know?
Sounds like that. How are you gonna know? How are
Yeah.
they gonna know? They will know. No, they will not.
Wait, I'm not gonna say when everybody's like,
Yeah.
no, I'm like, no, first signs I'm out, like, I'm not.
Would you do me a favor? Would you let us know which all rig you're going to be on in case we need you?
Good.
No,
Good.
no, I'm not looking up the
Yes.
It's not on the docket.
You know what?
Okay. All right, thank you.
Oh, sorry, everybody.
Hello. And you dated all of them.
I'll check.
You're such a dater. I appreciate that.
Try to be more like Michael every day. Be like Mike.
So.
You need a pen?
Yes. Thank you.
All right. So I don't know what the reason.
Oh, shoot. This one.
All right, thank you. All right, there you are.
Thank you.
And happy Friday the 13th. And could you speak with Diana? She seems to think that zombies can't swim.
I never said that.
I mean, I
I
never
never
really
said that.
thought about it, so
I mean, well,
I'm not a zombie expert. So
do I need to sign homework?
all I need to do, all I know is I want to be inside the zombie apocalypse house, like with the zombies on the exterior, where
Thank
we're
you.
inside, but
I'm gonna tell you,
why?
it's because somebody always has to be in control. There's always gonna be issues with leadership, always. I would.
No, there'll be no issues with leadership.
I need to speak. So,
This point.
and then there's somebody to throw to them to like get away. So, survival mode.
Reason why I don't group up to nobody.
She's gonna be on her own.
Oh,
And I will survive.
Hold on.
Well,
Thank you. Thank you. There's kind of reductions this week also, so at least I want, I'll try to make that happen, so definitely. The Brussels sprouts, they're good. They're very good. Yeah, I went there, tried a couple other things with a friend. And we had, this noodles, like wagyu beef, that you might actually like, it wasn't fried. Mhm. And they like, yeah, and they like a tonka, like soup. That had like shrimp in it, that was very good also, it's like a lot of noodle stuff, but like noodle stuff.
Oh, cool.
Then we got the green beans and Brussels sprouts, I'm like, oh, Jerry was on, yeah.
I mean, that was perfect. I did that.
Yeah, I ate it, yeah. Yeah, my happy is like my soul mission and so
Everybody.
really not. Like my brother, my destroyed. Every once in a while. I get to leave early today. Okay, but at least you're gonna do it. I thought.
Don't you hear that?
What?
Getting
We get to
released
leave,
too.
we get to leave early today.
Oh, we do?
What's going on downtown, the 50th anniversary of the Spurs.
Oh.
The Alamo Dome.
But they say you just have to be careful of I-37 and 281. So we're on De La Rosa.
Yeah, but. Hey,
Party.
hey.
Go home also.
Anybody that goes that way gets to leave early.
Yeah. Hey, you're talking,
A lot of people go that way now.
you know what? You're talking to a via bus rider. So just take Fredericksburg Road. It'll take you through the entire city.
Oh, really?
Oh, wait a minute. Where are you headed?
186.
Well, yeah, this one,
Why?
like, yeah.
Because it's evidence exchange. I'm waiting for.
Anyway, hiding down.
All right, who are you conferring with?
Oh. On the left.
All right, and is your client in custody
No.
on bond? And where's your client?
Oh, Mr. Marine.
All right, is he here?
Oh, he will be here.
No, is he here?
Mr. Marine, he will be here. I will text him. I'll make sure.
All right, so here's the thing. I know people are heading to different courts, but we want to move quickly.
Because of Spurs.
Well, no, not because of the Spurs. It's just because people are here waiting.
Yes, I understand. I won't be far. I promise.
All right.
Thank you.
I hope Deputy Laura doesn't have to find you.
But tell her where to find me. Tell her.
He said he'll be in the 186.
And the 399. And
All right.
thank you.
We've got a bat signal to send out for you.
Thank you.
But he will murder.
I'll be back. I'm already. Miss Marie.
This guy was. I think I'm always honest with this country stuff. And the only thing that like you make any sense is but we're just excited. Oh, right, like.
I brought up, I know.
Yeah. Okay, thank you so much.
Oh, and Caroline, this is on the mic, can you write in the file that it was dismissed? All right, thank you. Who's here on Ashley Windrum? And Ashley Windrum, come forward.
Ashley, what do you think? Great.
Deputy Laura, is this on the docket?
We said it for hearing.
All right. Oh, and so what's happening here?
Judge, we have a motion. Remove the no contact order. Originally on the motion, I had both the Gregory and Alicia Manning. which is
All
her
right, don't
grandparents.
stand on the microphone.
Oh, I didn't even realize that microphone was there. Sorry.
That's okay.
Uh,
All right, so let me ask you this, is Gregory Manning and Alicia Manning here?
They are here, and what I wanted to correct is apparently Alicia Manning is already a no harm or injury, so we really just need to address Gregory.
All right,
And he is here today.
okay. So we're gonna go on the record. If I could, everyone, please make sure that you are whispering. Court is calling 2023 CR 0027, State of Texas versus Ashley Starr Windrum. Can I have parties announced for the record for the state?
Michael Villarreal, the state.
Defense?
Linda Corley.
And are you Ashley Windrum? All right, you're gonna have to speak up.
Yes, Your Honor.
All right, we're here on motion to amend bond conditions. Defense, you're asking that the no contact order be lifted with regards to Gregory Manning?
Yes, Your Honor. Alicia Manning is already a no harm or injurious contact order. And I had included her on the motion. At that time, I wasn't aware. I thought they were both no contact orders.
All right, and what is her relationship to Gregory Manning?
Grandparents,
All right.
grandfather.
State, do you have an objection to this motion?
I don't, Judge. We've previously spoken to the complainant in the case. As well as we've been provided some mitigating factors relates to the case. But at this point, we don't anticipate that there would be a continued threat, and it's the wish of the complainant that they have contact. And so based on all of those things, we don't have an objection to this being changed to no harm, no injuries.
All right, and what sort of contact is she hoping to have?
Judge, I think that they were hoping that she could live at their residence now. She's their granddaughter.
I mean, I understand it. Where are her parents?
Judge, I'm not aware of her relationship, and caretaking has been with her grandparents.
All right, let me, if y'all could have Gregory Manning or either Alicia Manning approach.
They're both here.
All right, either one, whoever you wish to call.
We'll bring Gregory up since he has their contact order.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you could state your name for the record.
Gregory Charles Manning.
All right, do either of you have any questions?
Judge, Mr. Manning, it's your wish for your granddaughter to be able to have contact with you and reside with you, is that correct?
Correct.
And do you feel there's any threat to you at this point?
No, I don't.
That's all my questions, Judge. Pass.
Just a couple questions. At the time of this offense, she was residing, correct?
Okay, I'm so sorry. You are going to need to speak up.
The judge and the court reporter have to hear you, so.
That is correct. She was living with us at the time.
Okay, and how long has she been living with you prior to the day of the incident?
I want to say a year and a half, possibly.
Okay. If she weren't. If she's not able to live with you, do you know where she'd be able to reside?
No, I don't, sir.
Does she have any contact with her parents?
Yes, the mother, yes.
Okay. If the court were not to at this point allow her to reside with you, would she be able to live with her mother?
All right, everyone, excuse me. If you're in the jury box, I'm going to have to, just 1 second. If you're in the jury box, I'm going to have to ask that you be quiet because we're on the record and it makes it difficult for the court reporter to hear. And as everyone knows, I like to make people's job as easy as possible. So could somebody let Mr. Featherston know?
Bob.
Okay, thank you.
If you could repeat your answer.
The mother did not have the wherewithal to have the daughter living with her.
And are you aware, is she receiving any type of mental health or counseling currently?
Yes, she is.
Okay, and do you believe that that is helping her with any potential issues that might arise?
I do, sir.
I'll pass it.
All right, so I don't,
She has been through counseling and she also has a current appointment schedule. She's on medication, she's compliant. She has an appointment schedule with her psychiatrist and her new therapist that'll be long-term.
all right. So, Mr. Manning, I'm assuming that while this case has been pending, you've not had any contact with her?
That is correct, Your Honor.
All
Yes.
right. So I don't know any of the facts of this case, but do you believe whatever happened at the household had something to do with her medications or not being on medications?
I think it had something to do with her medications not being correct. Yes, ma'am.
All right. Have you ever had any issues before? And when I say issues, I mean
No, Your Honor.
of this nature.
No, Your Honor.
All right. And are you afraid of her?
No, Your Honor.
And if something were to happen again, what would you do?
Probably remove myself from the situation and let the police know.
And with regards to this incident, was the police called?
They were, Your Honor. Yes,
And who called the police?
a helpful pedestrian.
All right, so did this incident allegedly occur somewhere other than inside the home?
It began in the home, Your Honor, and then the defendant proceeded to noisily take it to the street.
All right, thank you. Any other questions?
Nothing further to say.
All right, thank you.
Thank you, Judge.
All right. And if I could see Alicia Manning, please. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. Could you state your name for the record?
Alicia Manning.
So my understanding is that the no contact order was lifted with you. So have you had contact with her since this incident?
Yes, I have.
All right, have you seen any changes?
Yes, I have. I've been the one taking her to therapy and the intensive care patient.
right.
So I've had contact with her. And she's doing a lot better.
So other than this incident, has anything ever escalated to this point? All right. And do you have any fear?
None at all.
And if this were to escalate to this point, what would you do?
I would just get help. I would get into the crisis center.
All right. Any other questions from either side?
None from defense, Your Honor.
No, Judge.
All right. Oh, and I'm sorry, one final thing. I making the assumption, and if it's not a correct assumption, let me know. It appears that she's going to be living in your household. Is that correct?
Yes.
All right, thank you. All right. Anything else from either side?
Nothing further, Your Honor.
All right, Ms. Wyndham, you can take your position. And Ms. Wyndham, I just have a few questions for you. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, state your name for the record.
Ashley Star Windrum.
All right. So are you taking your medications?
I am.
And do you have a case manager?
Yes, I do.
And are you in contact with that case manager?
I think she misunderstood, Judge. She means so you had gone through counseling, correct? Yes. Okay, and you have an appointment set up with a psychiatrist. I do. Do you have anyone other than your prior therapist? Are they following up with you, or who is that person? Shelley Gilbert. Okay.
Okay. And so you know who to call if there is a crisis?
I do.
All right, and who would you call?
Shelley Gilbert or the crisis line.
Okay.
It's a hotline.
All right, and where have you been living since you haven't been living with your grandparents?
I've been living with a family friend, Denise McFarrell.
Okay. And is your plan, if I were to lift this no contact order, is your plan to live with your grandparents?
Yes, Your Honor.
All right. Are you employed?
Not currently.
All right. So what do you do in your spare time?
I'm in online schooling.
What are you studying?
I'm still in high school.
Ah, okay.
It's just online.
All right. All right. The court, if there is nothing further, the court will grant your motion.
Nothing from defense.
Right. So with regards to the actual case, you can have a seat. With regards to the actual case, have you all been conferring?
We have, Your Honor, and they have given us an offer. We also were going to be investigating if there might be a possibility for PTD in this case. I'm not sure if that would be a possibility or not, but we just need some time to further try to do that. You know, we've got to talk to some folks.
All right. Could I have a 30-day reset on Ashley Wyndham, please?
What's the date now?
Yes, please.
It'll be February 10th.
All right. And if you could give them a reset form, please.
Yes.
All right. So you'll be back on February 10th at 9 a.m.
Yes, Your Honor. Thank
And
you.
once you all have signed the reset form, you're excused.
Thank you, Judge.
And if you would like a copy of the order, just let the clerks know.
I appreciate it.
Who's here on Michael Schumacher or Shoemaker? All right, and Shoemaker, if you come forward. Oh, Mr. Smith, you're over there. All right, and Mr. Smith, how did your trial go in Comal County?
Came in first.
Okay. All right, court is going to call 2019 CR 11017W, State of Texas versus Paul Michael Shoemaker. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
All Judge Smith for the defense.
All right, Mr. Shoemaker, I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Michael Paul Shoemaker who was placed on deferred adjudication in 2019 CR 11017W for the offense of possession of a controlled substance penalty group 1, less than 1 gram in a drug-free zone on October 8, 2019 for a period of 6 years. Is that you?
Yes, ma'am.
State?
Violated condition number 5 in Dare County, Texas. The defendant, Michael Paul Shoemaker, did then and there fail to report to the supervision officer as directed for the month of June 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True. Judge, state waive all the violations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Your Honor. It's to continue the defendant on supervision, but to alter and amend for him to complete bid class and to be placed in MIC solid.
Okay. Is that the agreement?
It is, Your Honor. If I might, real quick, my client is currently on parole. Halfway house in Austin.
Yes, ma'am.
He's out of Wilson County, I believe, on parole, but they just paroled him out.
Yes.
Okay, everybody is whispering, or either my allergy ear is acting up.
He was placed on he's on parole out of Wilson County. He's placed in Austin.
The halfway house.
Halfway house there. And we'd asked that be worked around conditions so that they are essentially running together.
All right, and under what case number is he supposed to be at the halfway house in Austin?
Out of the Wilson County.
Yeah, out of Wilson County.
Yeah, but what's the case number?
I don't know.
And do we even know if the halfway,
That's how my NPR.
what does anyone even know if the halfway house is going to accept him? Because obviously Wilson County knows that he's here on a
Yeah,
motion to revoke.
Parole came and saw me as soon as I got here, because Bear County picked me up from TDC. Parole came and saw me here, reinstated my parole, and I have a spot at the halfway house once I get this taken care of here.
All right, and what are you on parole for?
Tampering with evidence out of Wilson County,
And how long are you on parole for that?
11 months.
Okay. All right, the court will follow your agreement. Is there drug issues here? Because obviously he's at a halfway house.
No, because I had nowhere to parole to.
So you're at a halfway house because you don't have a place to live,
Yes, ma'am.
not for any drug issues.
No, ma'am.
Not for mental health issues.
Family or nothing here, so I had nowhere to parole to. I didn't have an address to parole to. So parole is sending me to the halfway house in Austin.
All right, so if he has a place to stay, then what are they going to do with his parole?
I guess, continue it for 11 months and then discharge him as long as he hasn't met violations.
This is what I'm trying to figure out, and this is my concern. So he's telling me that he is paroled to this halfway house in Austin because he doesn't have a place to stay. But his probation is here in Bear County. And we have Haven for Hope right here in Bear County. I don't understand how he's going to be successful on probation. Probation? Are we transferring this to Austin? And if I don't even know if Austin, I know everybody is saying that Austin will accept him, but I don't know if they will really accept him if he has probation here. And they're saying, oh, he doesn't have a place to stay. So we're going to put him at a halfway house in Austin when we have facilities here in Bear County.
If we do place him here, parole, my understanding is they would continue the supervision because he'd be subject to the jurisdiction of 187. And as long as he didn't commit violations, things for purposes of your deferred, if he spends the time here and completes what he's supposed to do, we can transfer or bring it here. Your court would have prevailing jurisdiction over the parole.
See, I don't think it will because I don't have any jurisdiction on a parole. And I think everybody here is making assumptions. Has anyone called his parole officer and said, we have a motion to revoke happening here in Bexar County, the 187th District Court. If I were to say that he is to live here in Bexar County, would that negatively impact their decision to have him living at a halfway house? Does anybody want to call and see? Because I'd hate to set him up for failure.
Very good point, Your Honor. I don't mind doing that. The answer is no, I haven't done that.
All right, so let's step back, see if you can get in touch with parole. If you can't get in touch with them today, then we'll reschedule this, but just see if you can get in touch with them. And then I can make a ruling.
Very well.
All
Thank
right,
you.
you're welcome. Mark Lewis. Who's here on Mark Lewis?
And Your Honor.
Thank you.
President Johnson.
That's me speaking of the stuff.
Yes. You are just, and you're dating everything. Oh, I forgot to tell you, Happy New Year. You are. You're welcome. All right, the court is calling 2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
All J. Smith for the defense.
And are you Mr. Lewis?
Yes, ma'am.
All right, off the record for a moment. This one, they're gonna come back on that one. All right, we're back on the record. We're here for sentencing. You entered a plea of no contest on November 28th. Applied for deferred adjudication. The court ordered a TAP evaluation and PSI. According to the plea bargaining agreement, punishments be assessed at 6 years in the prison. The state is opposing your application. They're taking in consideration County Court Cause number 686624. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
The defense has, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, are there any witnesses, state?
No, Your Honor.
Defense?
Perhaps my client, but his statement is asking for and included in the application. The reason he believes that he can successfully complete a deferred at this point in time of his life.
All right, the court is, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Mark Lewis.
All right, defense.
Mr. Lewis, did you file voluntarily a motion for deferred or asking the court to assess punishment by way of a deferred probation? Yes, I did. And we've noticed in your report that there have been juvenile incidences and prior instances. Have you, what is it about this application at this time that may result in a favorable outcome for you versus when you were much younger?
Well, of course, when I was younger, I was acting like a kid. I didn't think it would help me. I believed that I could do it my own way. Since that initial time frame, I've been to PUC. I now have a daughter. I've learned what my results will bring me. I was acting like a kid back then. I just thought I could BS my way through it to just try to reach my destination real fast, but I cheated myself.
And do you believe that alcohol and or drugs played a role in the offense that you pled no contest to?
Yes.
Have you got a potential place to live?
My bad.
If you were placed on deferred by this court?
At this point in time, I'll be residing at Haven for Hope in PCY Courtyard. My dad lives in Houston. He's looking into assisting me in financially helping me get an apartment within a small time frame, providing that I follow probation rules and successfully do a couple months of course, positive living, employment, classes, everything. Then my dad's willing to
ask his family to help me with a potential place.
And are you willing to allow the court to help you or address your drug usage?
Yes,
And if the court decides that there should be some classes or some skills or some programs that you attend, are you willing to do that?
yes,
Are you asking the court for support?
I am.
And is there anything else you'd like to tell the court that we have not covered?
No, I feel like we've been covered.
Ask the witness.
State?
Mr. Hughes, you've been previously placed on this list, correct? Yes, sir. Okay, and there several NTRs were filed in that case, is that correct? Yes, sir. And eventually that did result in the revoke. Yes. Yeah, and shortly after it would have been released, it was the same, but that first offense, it was violation of sex offender registration, correct? Yes. Okay, and shortly after that, you were booked again on violation of sex offender registration. Correct? Yes, sir. And there you were sentenced to 3 years state jail. Yeah, 2 years, yes, sir. So yeah, that might be a typo there, but,
All right, and that offense was related to something that when he was a juvenile, according to what I'm reading.
Right.
And so it was just, let's see, what did they call it? They called it prohibited sexual conduct.
Right.
And I see you have gang affiliation.
I did,
And what gang was that?
it was 5 days. Correct.
Okay. So why were you hanging around this hotel?
I was inebriated. I was charging my phone on a little outlet across from the Starbucks next to the hotel. I was downtown. I take some over-the-counter medication, and time just started fading away. I was charging my phone, and I dropped my charging cord in the grate. So I went away. I came back, and later on that night, I moved grate to get my charging cord, and it actually entered into it was a room, and I couldn't get back up. So I went through the door, and that's how I ended up in the hotel.
Okay, I don't understand your story. What do you mean you went back up?
No, like it was a grate in the ground.
Mhm.
It was like an air duct. My phone cord, when I unplugged it out of the wall port, it had fallen down into that grate. It was like a duct. I couldn't get back up because the ceiling was like up there, the actual street level.
Okay, so where were you charging your phone?
I was charged right across from the Starbucks.
So was it,
Major Hotel.
when you were charging your phone, that wasn't inside a facility that was outside?
Outside on the street level in the passageway between River Center Mall and the Major Hotel.
Okay. All right, anything else from either side?
Just argument.
I think your honor, accept the argument.
All right, I have a question, just as soon as probation is available, but I'll hear argument.
Judge really here. The two charges that he went to TDC for were violation of sex offender registration. Already shown those were conditions that he was given that he had to follow up with. Both occasions he was unable to do that. On the first occasion, it actually was, he was granted deferred. He was given the opportunity, he was given out to get help. And he didn't take advantage of it. Motion to revoke eventually filed, and he was sentenced to 18 months in state jail. The state's concern is just that it's a repeated history of not being able to follow regulations or rules that are set out for him. And when he was given a chance, he showed that he wasn't able to follow the rules. And that's where he was revoked and sentenced to prison.
All right. Probation? On this case, with the violation of sex offender registration, will SafeP accept him?
No, Your Honor.
ISF?
State ISF,
They will?
yes.
All right. So here's your choice, Mr. Lewis, and I've read the facts of this case. I'm going to give you a choice. State wants you to do 6 years in prison. I can put you on 10 years probation. It's going to be a conviction either way. I'm not giving you deferred adjudication. It will be a conviction. And I will place you on 10 years probation, or I will give you 3 years in the prison. Which would you prefer? And you are going to state ISF.
10 years probation.
All right, that's what the court is going to do. Sentence you to 6 years in the prison, suspended and probated for 10 years. There's $1,500 fine, probated. State ISF. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. No unsupervised contact with minors. I'm going to want field visits upon release 2 times per month. Defendant is to remain in custody until transfer to ISF. I'm going to want the UA hotline until further notice. And when he's released, I'm going to want 90 meetings in 90 days. Probation, is there anything else?
Your Honor, you mentioned sex offender, it's gonna have to be on some caseload or.
Okay, yes, he'll be on that caseload. You're going to be on the sex offender caseload. Not because this is a sex offender case itself, but because of your registration. And have him evaluated for MIC, because I'm reading in here, there's some mental health issues.
Yeah.
And I'm also going to do no contact. What are your parents' names?
It's Rhonda Sanford and Matthew Treadway.
All right, you're not to have any contact with your biological parents. Because I've read in the PSI report that you were taken into foster care because your parents were homeless, living out of vehicles, doing drugs. So you're not allowed to have any contact with them. Do you understand?
Your Honor, if I may speak, my birth mom and my birth dad, it was a one-time meet. I recently got in contact with my birth dad in 2020, whenever I paroled out of TVC, and he's my #1 supporter right now. My birth mom, I'm perfectly fine with that, no contact, because she has continued a drug use and like that lifestyle. She currently actually has a drug-related case. So I've already made it a point, and my dad knows this as well, that I don't want anything to do with her. My dad, he's my #1 supporter right now.
Mr. Smith, here's the thing. If you want that changed, your dad is going to have to present himself to the court.
Hey, he lives in Houston now.
All right, well, he can do it by Zoom. But I'm not going to let you have any contact for now.
Yes, ma'am.
All right, I'm going to show you, is there anything else, probation, with regards to sentencing? All right. Mr. Lewis, is there anything else you need from the court to be successful?
No, ma'am, thank you for the time.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Yes.
You're welcome. Who's here on Carlos Landaverte Martinez?
Here you are.
All right, if you'll come forward.
John, just a quick update. I spoke with my client. He has not been assigned, but he is to call the probation department once he's released from here on Mr. Shoemaker.
All right, but they still want him to go to a halfway house, so it's better to call the parole officer. Let's see what's going on.
I'm going to have to ask for a quick reset so that I can get in touch with him. They're out of, we haven't, I've got to get a hold of the office, run down his TEC number. And then.
Okay, are you able to Google parole
there is a
officer?
Way to look up the number.
Yeah, there is.
Who the officer is or which region.
Oh, no, if you, because I used to do a lot of parole cases. If you just Google parole office and you tell them what your client's TDC number is, they'll be able to tell you who the officer is and get you in contact with the hearings officer. And let me see. If I can figure out who that is. Oh, my internet is doing crazy things this morning. But if you will Google from your phone, parole office, Bexar County, they'll have a number for you.
Very well, yeah.
And so we will await you to come back on that.
Okay, I'll step out.
Thank you. All right, so we're here on Carlos Ladaverte. Could I have everyone in the box be quiet, please? All right, so what is happening with this case, counsel?
Your Honor, back in November, I filed a motion for a competency evaluation. Nothing has happened on it, Judge, until we're still waiting for my client to be evaluated.
All right. So have you been interviewed, Mr. Ladaverte?
No, nobody.
All right. Other than this, do you have discovery counsel?
Yes, Your Honor, I do.
All right, let me just email Magistrate Court. Does anyone know Judge Carruthers' coordinator? I know her first name is Angela. Does anyone know her last name?
Martinez.
Thank you. All right, so I sent an email to the court, so we will make sure we get that taken care of. And I'm going to give you 1 month reset. And you all can continue to negotiate off docket. I do realize that nothing can happen really with regards to movement until he has his evaluation. Could I have a 30-day reset on Mr. Ladaverte? And it's to get an update on his psych evaluation.
February
All right, so we're going to come back on February 10th. And counsel, if you can make sure that you go down to Judge Carruthers Court and just put this on their radar, even though I've sent an email, just make sure they're aware.
Yes, Your Honor.
All right, is there anything else from either side?
Nothing from the state. Your Honor.
Nothing further, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, thank you.
You're welcome, Your Honor.
All right, who's here on Eddie Marine? Eddie Marine. Who's here on Daniel Flores?
Yes, Your Honor.
Yes. All right, on this one, it's the DNA analysis.
Yes, Judge.
Do I need to go into the laboratory and make this happen myself, but then I would have to recuse myself?
Judge, you'd have to turn yourself into a police officer first.
All right, so I need to become a police officer, get it, and then go to the laboratory. I've watched DNA that comes on A&E. I think I could do it.
So the issue, Judge, is that we have serology and DNA done on what was submitted to the lab.
Mhm.
But the comparison of the male contributor was never done, so the bucket was never submitted. Well, last setting informed the detective, you need to get a search warrant to get the buckle, excuse me. And he did get a warrant, he was unable to locate the defendant, and so the warrant expired. So I've informed him that he needs to get another warrant. And I've been conferring with Ms. Farrs today, informed me and assured me that he is at the same address, but there was a period of time that he was potentially away on vacation. That might have been the issue. But confirm the address. So with that, I'm going to let him know that he needs to do it ASAP, not the ASAP that you use, but the ASAP that most of us use.
Yes.
In order to have a comparison done, because there is an unknown male contributor on the case.
All right. So this is what I'm going to do. I'm going to reset this case. And if the buccal swab is not done, if there's been no movement, then on the day that I give you, that officer needs to show up to court.
Yes, sir.
All right. Could I have a 1 month reset, please?
Yes, Judge. February 10th.
All right. We'll be back on February 10th. And if you all will get the reset form, is there anything else, counsel?
No, Your Honor.
All right. Thank you. Martin Rios. Good morning. So what is happening with this case?
Pardon, Your Honor, Judge, we've conferred, I conferred with Mr. Rios. There is an assault bodily injury case involving his sister that I don't really know anything about yet, pre-indictment. I need to look into that, and there's a little bit more discovery on the aggravated assault case that I need to.
Okay, just 1 second. For some reason, I don't have my docket. Does anyone have an extra docket? Oh, thank you so much. All right, so this new case, are you the attorney on the new case? Here you are, Caroline. Thank you.
I would, yes, I would assume so, Your Honor.
And so you're just waiting for upload of discovery on that, or has it been uploaded?
Judge, I don't know if it's been uploaded, but I have not looked at it.
Okay,
I don't know if he gets access to it until if it's indicted, I can turn that over to him. It's a family violence case. But I think globally speaking, I don't think an offer has been made yet. that does all of the cases, but we tried to contact the victim. I've informed my CDL that she needs to contact the victim on that case as soon as possible. I said, regardless of whether they have successful contact or not, we can have a global offer next set.
Okay. All right. So all the discovery is available.
I don't know if he gets access. This is part of my lack of knowledge, and he might be able to better inform. I don't know if he gets access to it until the case is indicted.
Okay.
It's not sealed, but there is, the full discovery appears to be there. And I can, if he wants to provide me like a flash that, I can give it to him.
All right.
Judge, I should be completely up to speed on discovery on both cases by next Sunday.
All right. So could I have a 1 month reset on Martin Rios, please? All right. So we're going to come back on February 10th. On February 10th states you'll need to make an offer.
Yes, sir.
All right. Thank you.
Thank you, Your Honor.
You're welcome. Have a good day.
You want to know about me? You had called my line and I was outside for a minute. Okay,
All right. You'll be coming back up.
thank you.
Do not leave the courtroom.
Apologize.
Arturo Vara. All right. What is happening with Mr. Vara? Who have you been conferring with?
Judge, I conferred very briefly with Mr. Garahan,
Mhm.
but very briefly because I'm scheduled to pick a jury in the 144th this morning
Oh, what will you be trying?
and aggravated sexual assault and aggravated kidnapping.
Okay.
So but I did let Mr. Garahan know that the issues with the case, what we have been talking about with Ryan Groomer before he left. So Mr. Garahan's gonna follow up on those, and then him and I will follow up next week or the week after.
All right. Could I get a reset on Mr. Vara for how long do you expect your jury trial to last?
Judge, the state announced 2 weeks.
Okay. All right, let me recall this then for 1 month. You all need to confer off docket. And when you all come back, I'm going to give you a quick plea deadline date turnaround, and then it will either be pled or going to jury trial.
That's wrong.
February 10th.
All right, February 10th, you receive your reset form and then you're free to go.
Thank you, Judge.
You're welcome. Who's here on Jeffrey Adames?
Morning, Judge.
Good morning. Are you getting enough sleep?
I am. She's actually waking up a little bit less than last year. Oh, yeah, sure. The last few nights.
Oh, wow.
So,
But she's still letting you know she's running the household.
oh, definitely. She's about, tomorrow will be 5 months old.
Oh, that's the rough sleep.
You know, I think, as we get older, we should still calculate our age in months so we can still like we're young at heart.
I feel like I feel really old. What, 400 months?
I mean, that sounds good. Then people will be thinking about it in their head and they'll be like, well, that's not bad. All right, the court is calling 2022 CR 0491, State of Texas versus Jeffrey A. Adames. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Nathaniel Navy, Your Honor.
Are you Mr. Adames? Yeah. All right, I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jeffrey A. Adames who was placed on community supervision in 2022 CR 0491 for the offense of assault, family choking, strangulation on February 23rd, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
State?
Your Honor, in violation of condition number 2, on or about the 27th day of June 2022 in Wilson County, Texas, the defendant Jeffrey A. Adames did then and there illegally use a controlled substance, namely amphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
And
Very true.
we will waive the remaining conditions.
Any objections to the waivers? Mr. Adames, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you to 5 years in prison until a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there an agreement?
Your Honor, we do have an agreed recommendation to deny this motion, but to alter it and amend for lifetime recovery. I believe there's a 2-week waiting period in jail.
That's correct, Judge. My client has been very honest and admits that he would like some sort of inpatient treatment. And that's the one that we discussed and think is the most appropriate.
And has anyone checked with lifetime recovery?
I talked to probation and I believe that the wait time is about 2 weeks.
All right, and Mr. Adames, is this what you're requesting?
Yes, ma'am.
All right, how often are you using drugs before you were taken into custody?
I was using quite often for numerous years, 25 plus years. I quit 3 months ago. I quit 2 months on my own, and then I was going to turn myself in for the treatment because I was offered outpatient, but I said, is there any way I can get inpatient so that I'm not close to it? I mean,
So how much were you using?
I was using maybe a half a gram a day for almost 20 years.
Okay,
So, I mean, that's just, well, I'm 50 years old when I stopped, you know. I took the first step in doing my own, which is pretty hard after so many years. So I figured a little bit more help wouldn't hurt.
all right, this is what the court is going to do. The court denied the motion, alternate amend conditions to include lifetime recovery. He's to remain in custody until transfer to lifetime recovery. After he is at lifetime recovery and has completed it, I want a referral to felony drug court. And I'm going to want the UA hotline upon release and field visits 2 times per month. Now, if he is in felony drug court, then felony drug court can handle the UA hotline and all of that. And probation, I don't know, it may be wise to do the referral to felony drug court and just let them know that I'm sending him to lifetime recovery because they may not have room. And if they don't, they can already put him on the waiting list. And by the time he's released from lifetime recovery, they'll be ready for him. All right. So, Mr. Adames, I'm following your agreement partially. So I'm going to send you to lifetime recovery, but I think you're going to need more than lifetime recovery. I think you need felony drug court. It's important that you're 100% honest with them. It is a hard program. I remember when the program first started and I was attorney in that program, people thought it was easy. In actuality, felony drug court is harder than being on probation. It's harder than going to prison. So if you're honest with them, they'll accept you. They will work with you. Hopefully you'll learn something and be able to control your addictions.
I'm ready to stop. When I have kids, I lost, and I'd like to get them back.
All right. Good luck to you.
Thank you, ma'am.
All right. Thank you. All right, Eddie Marine. Where's your client?
Marine, stand up, please.
Come forward.
Come forward, please.
Have you conferred with the state?
I have conferred, Your Honor. I have received all.
You're on this side.
I have received.
You're on this side and your client's in the middle.
Good morning, Your Honor.
Yes.
Happy New Year.
Happy New Year.
I have received all discovery. I have received an offer. It expires in 30 days.
Well, no. Because, and this is why I'm saying no. Because we're here on October 3rd. And on October 3rd, in my notes, I have all discovery received, offered, tender. Plea deadline date is October 21st. And then we came back on December 14th, and you were in trial in Uvalde County. And then we were here yesterday, and at your request, it was brought back today. So plea deadline is today.
Yes, Your Honor. I will advise my client.
All right, so step back and let me know what you all decide.
Perfect. I
Thank-
didn't realize.
Oh, no problem. Angel Gonzalez. Thank you. All right, so we were last here for discovery on some medical records.
medical records, Judge, and then I recently received, right before I left for the holidays, so I'm
Mhm.
kind of getting back up to speed, a disc containing the cell phone extraction. So my investigator has not yet had a chance to go through that. I barely started going through it. I'm sure, as you know, those can be pretty
Mhm.
tedious sometimes and lengthy. So I don't know what you prefer. I have not yet gotten an offer from the state. I know there's a new attorney, and so I'll. talk to
So do you have all the discovery?
I think I do. I think
Okay.
I have everything that I need now. I just would like a little bit more time to go through everything and have maybe one last regular reset
All
before
right.
we.
Could I get a month reset, please? Oh, she's on the phone. Hi, could I get a 1 month reset?
Yes, Judge.
All right, so we're going to be back on February 10th. On February 10th, this is what the court is going to be expecting. I'm going to want a discovery acknowledgement signed. And I'm going to want an offer to be tendered.
That's perfect, Judge. Thank you. And in the meantime, I will try to get with Brittany and so we can confirm between now and then.
Okay, so what's going to happen with your case, Mr. Gonzalez, is the next time we're here, your attorney will let me know that she has all the discovery. She's going to sign a discovery acknowledgement stating she has all the discovery. The state is going to tender you an offer. And then once that offer is tendered, you can either accept it or not accept it. Or if you want time to think about it, I usually give plea deadline dates. So if you want time to think about it, once they give you the offer, I'll give you a plea deadline date, and then we will come back on that plea deadline date. Do you understand? Do you have any questions about anything? All right, thank you.
Thank you so much, Judge.
You're welcome. And Caroline, this one is done. Oh, no, is that done? Okay, this one, they're confirmed. Oh. All right, Eddie Marine. All right, what is happening with this case?
Your Honor, I stand corrected and I apologize for misspeaking earlier. I stand corrected, you were right. He already had an offer before, but today he got a better offer. He's rejecting it. And at this point, he's asking the court for time to get maybe his own lawyer for trial. Thank you.
All right, thank you. No, we're setting this for jury trial. State, how long will it take?
Is that the case, Judge?
Yes.
Probably just 2 days on the test.
All right. So can I have a jury trial date, please? The first available date. They're telling me it will be 2 days. Are you able to put this on January? Just 1 second. Are you able to put this on January 23rd?
Yes, Judge.
All right, so you're going to come back on January 23rd.
Thank you, Your Honor.
You will get a reset form.
Appreciate you.
And could you make them put on there that it's for jury trial?
Yes.
And you'll probably be called back on the 24th, but you'll need to be here on the 23rd.
I just have to be there on the 25th.
Yeah, it's jury trial.
Okay.
Oh, you know what? Excuse me. I'm sorry. Make that the 24th. Yes, because our juries come up on Tuesday.
If I may, Porter,
Yes.
it says right now, I have a case in the name of financial funds.
Oh, Del Rio is going to have to fall by the wayside. So you'll be here.
Thank you.
So I'll see you here on the January 24th for jury trial.
Okay. Thank you.
And I will tell you, Judge Angelini is going to expect you to be here on the 24th.
Thank you.
All right. And state on Marine, I need a acknowledgement of discovery done, please.
You're good.
All right, thank you. So don't leave till you sign the acknowledgement of discovery.
May I approach again? I don't know that I can make this go away.
Yeah, we have jury trial on the 24th.
But I want to make you aware.
No, I'm aware. I'll see you on the 24th. Thank you.
Mr. Mine?
On Malik Baloo, I know Melissa Christian is not going to be here. What date was that placed on? Okay, because they didn't order him because she was not going to be here. So I'll find out what date we're going to put that on. And then the attorney who has Mr. Xavier. No, he hasn't, Xavier Griffin is logged on. Could you call him because the attorney hasn't logged in? All right, thank you.
Well, no, I just need to know. But. Okay, I'll let you know.
Judge,
Yes.
sorry, I don't know how do you want the discovery acknowledgement for that?
Yes.
Okay.
Thank you. Yes.
Thank you.
See you on the 24th.
Oh, I just wanted to make it clear, I have to file a vote, unless it goes away in Del Rio, I have to file a motion to continue on this matter here. Because the guy in Del Rio has been waiting for a long time, he's in jail, everything.
Yeah, your client has been waiting for a long time. We'll see you on the 24th.
Thank you, Anna. Thank you.
Sure. And if you want that motion for continuance heard, you need to be here on the 24th to have it heard.
Maybe before, because I have to be in Del Rio that day, in federal court.
Oh, yeah. Come on down on the 23rd and have it heard then.
Thank you.
And you need to make sure your client is here on the 23rd to have it heard.
Thank you.
You're welcome.
Have a good weekend.
All right, you too.
Thank you.
All right.
You don't have a.
No, what is the attorney saying? Oh, yes, I do. No, I hear you. Welcome. Okay, awesome. Yay. All right, thank you. No problem.
Yeah. Right. You should get 5 and 5. At least. Well, you look like that. From this commentary. It's going to sound. No.
Who's here for Igor Orlinsky?
You come up.
Yes. Who's the prosecutor? Okay. Court is calling 2022 CR 0266. He needs to be in the middle. State of Texas versus Igor Orlinsky. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Ken Locke for Igor Olinsky.
And are you Igor Orlinsky?
Yes, sir.
Showing you what's entitled motion to enter adjudication of guilty and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilty and revoke probation. Did you review that with your attorney? Did you understand it?
Yes, sir.
All right, off the record for a moment. I'm sorry, I'm gonna have to ask you all to be quiet in the box while we're on the record. All right, we're back on the record. Are you the same Igor Orlinsky who was placed on deferred adjudication in 2022 CR 0266 for the offense of violation bond or protective order stalking on June 6, 2022 for a period of 6 years? Is that you?
Yes, sir.
State?
Your Honor, in violation of condition number 4 in Bexar County, Texas, the defendant Igor Orlinsky did then and there fail to report to the supervision officer as directed for the month of November 2022 in violation of condition number 4.
How do you plead to that? True or not true?
And Your Honor, we'll waive the remaining.
Any objections to the state's waivers?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty and sentence you to 10 years in prison and up to $10,000 fine?
Sure.
Knowing that, do you still wish to plead true to violation of condition number 4?
Sure.
Court will find violation of condition number 4 true. Is there an agreement?
Your Honor, we do have an agreed recommendation to deny the motion to assess a 30-day jail sanction to alter and amend for bi-weekly, meaning twice a week visitations for the first 90 days upon release, and to require him to re-enroll in the BIP program within 5 days of his release.
All right, is that the agreement?
What is the agreement, Your Honor?
All right, so here's the court's issue. And I don't take the other allegations as true because you all weighed them. But I have you on GPS and you're not charging your device. I don't understand this.
Busy with work, I guess, forget the things I usually do.
All right. So I could send you to prison for 10 years and they'll put you on a schedule. And you may have work at the prison. I don't know if they still do the thing like they do in the movies where you make license plates and you get paid $1 a license plate or 50 cents. So would you like to not be busy at the jail or at the prison? Because I can arrange that.
Not on the table, Your Honor.
Well, here's the thing. You're going back on GPS. And if you don't charge that GPS, you're going to potentially go to prison for up to 10 years. Do you understand?
I do.
Now, here's my question. Explain to me why I shouldn't send you to prison. What has he done since he's been on probation? Has he done anything?
I believe he completed the parenting course.
What have you completed?
Been doing my drug tests, all the appointments, what I'm supposed to make. My probation officer, I keep paying fees. Yes, I'm also employed.
He did get a job, Your Honor. And one thing, when I pulled up the original conditions, it did say partial GPS with proof of employment. I don't know if that was done. I know as part of his condition of bond, I requested full GPS.
Okay, off the record for a moment. To the prosecutors with Adrian Perez. He is on Zoom now and he says he's awaiting paperwork.
Judge, really quickly, we still needed the email for the bail iPad, but I haven't been given that yet.
All right, Caroline. All right, they'll get that for you. And Adrian, what I'm going to do is I'm going to send you and your client to breakout room number 1.
Okay, thank you, Judge.
You're welcome. All right, we're back on the record. So what would you like to do? Here's the thing. This is what I can do. I will send you to prison for 3 years. You can do whatever they want you to do at the prison. And you will be done with this probation. Or I can continue you, but you are going to be on GPS and you will follow the rules of GPS.
I would like to continue with my probation, Your Honor.
All right, this is what the court will do. The court is finding violation of condition number 4 true. The court will deny the motion. All right, Mr. Pettis, you're supposed to go to breakout room number 1.
Yes, Your Honor. I was just there. I'm sorry. Could you have the prosecutor call me on my cell phone? I need to talk to him, please.
Sure.
Thank you.
You're welcome. To the prosecutor, do you have a cell number?
I do.
All right, if you were to approach Caroline, they have it. Thank you. All right, we're back on the record. The court will deny the motion, alternate man conditions to include GPS. And that will be partial for work only. I'm going to want field visits 1 time per month. He's going to enroll. You said the BIP program?
Yeah.
You're going to enroll in BIP within 1 week. And all of the conditions will remain. So your GPS, you're only allowed to go to work. You're not allowed to go to the grocery store. You're not allowed to do anything else. It's work. If you need groceries and you live by yourself, you're going to have to use Instacart. Do you understand?
I do, Your Honor.
Or some other thing that they use. All right. Is there anything else you need to be successful?
No.
All right. Good luck to you. I don't want to see you back here for this again. You understand?
Yes, Your Honor.
Thank you, Your Honor.
You're welcome.
Want me to be excused?
Yes.
Who's here on Tanisha Ollison? All right, if Miss Ollison will come forward. All right, what is happening with this case?
Yes, Your Honor. It's my understanding that this is our first appearance after the case has been indicted. Mr. Nettles is the attorney of record. I looked through the state's file. There is a lot of the criminal history and reports to that nature, but there's no prosecution guide, pictures, witness statements, anything like that. So we'd ask that it would be pushed to the next setting so we can, the state can get their discovery and tender it to us for review.
We have the discovery, it's just not in physical file, it's on e-discovery, so they have to download it.
All right. Can I have a 30-day reset for discovery, please?
Thank you. Sorry.
Oh, could I have a 30-day reset for discovery on Tanisha Ollison?
Yes, Judge, we could do February 10th.
All right, so we're going to come back on February 10th. And after you receive your reset form, you're excused.
Your Honor.
You're welcome. All right, we're back here on Shoemaker. All right, so what have we discovered with Mr. Shoemaker?
Judge, probation has more information.
Yes, Your Honor, I spoke with the assigned officer to Mr. Shoemaker, and she says that he is currently on parole. He'll be on parole until December 18th of 2023.
Mhm.
He has a protective order where he lived in Livonia.
Mhm.
With parole, he'll have to have an electronic monitoring. And then a substance abuse treatment. She could not get any information as far as the substance abuse treatment. Is it gonna be inpatient, outpatient? However, she did say that there is a possibility of the halfway house, but he has to call parole once he's released so that he can get the bed.
All right, so will there be any objection from parole if he remains in Bear County or no?
I didn't speak with the parole officer.
We did not, we were not successful in getting hold of them. Theoretically, he has not been assigned a parole officer, even though I had the number. Like they said, we would have an officer for him, so he's under Bear County, I believe. So.
Okay, so we're going to go back on the record in 2019 CR 11017W, State of Texas versus Michael Paul Shoemaker. All right, do you have a drug issue, sir?
No, not no more, ma'am.
What does that mean?
I.
When's the last time you used?
Oh, it's been a couple of years now.
And what were you using?
Meth and marijuana.
And how did you stop using?
I just, like, I had to be done. I was drinking and I stopped drinking and then I had to be done. I was losing everything. I hit my body.
Okay. So this is,
Going at TDC was an eye opener for me and now here I am. With nothing.
all right, who do you know in Livonia?
That I lived there with my wife and my son. Then that's who the protective order is again. So other than that, I have no family in the state of Texas. My closest family is in California.
All right.
So that's the reason of the halfway house, because I don't have an address.
So are you asking for a transfer to California or wherever?
I mean, is that an option?
Well, it would depend on what parole says.
See, so I haven't even talked, like parole talked to me at TDC and then parole talked to me when I got here. I haven't talked to an officer. I haven't talked to, physically haven't talked to parole yet.
And that is consistent. When I called him and gave him a TDC number, he had not been assigned.
All right, on this case, this is what we're going to do. Let's recall this for next week so you can get in touch with his parole officer so I can set conditions and hopefully those conditions will mesh with whatever parole is doing. And if you can find out for parole, if parole is okay with him transferring where his relatives are or not, they may say yes, they may say no.
And I would prefer that, so that way when I don't want to be homeless out here when parole runs up.
All right, so can we recall this for January 17th?
Yes, Judge.
All right.
Thank you.
Thanks, sir.
Yeah, I actually.
Caroline, is Youngblood on the docket? Youngblood, is he on the docket? Okay. Okay. Thank you. All right, who's here on Youngblood? Yes. All right, court is calling night mag number 690080, State of Texas versus Jackson Youngblood. Could I have parties announced for the record for the state?
Jason Garrett.
Defense.
From Mr. Youngblood.
And are you Mr. Youngblood? All right, you're requesting a PR bond for the offense of possession of controlled substance penalty group 1 gram to 4 grams. Is that correct?
Yep.
All right, state, any objections?
Judge, no, currently I think the bond is set at $200. And the state does not have the lab results back yet. I just checked that on the computer. So state does not object at this point.
I'm sorry.
The state does not object at this point.
Okay. All right, are you going to call your client? Because there are questions I need from your client.
No, Your Honor, I was just, I did inform him that I'm sure you had some questions.
All right, Mr. Youngblood, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. All right, Have you used any drugs in the past?
Yes, ma'am.
What have you been using?
Meth and weed.
When's the last time you used meth?
The night I got locked up on December 6th of last year.
Do you have any place to stay?
Right now, I've already talked with my the lady from Haven for Hope,
Hmm.
and I have a bed waiting. I talked to her in December. She said a couple of days, but I've been waiting on court. So I do have that, as well as a drug program waiting for me at Haven from after the upon release from here.
Do you have any children?
I do not know.
Right, so I do have a question with regards to the offenses, the bodily injury. Who's the complainant on that? Does anyone know? Who was the complainant on that?
It was some guy I got into it with on the streets. I don't know.
Well,
his
no,
name.
because it wouldn't. The terroristic threat, is that some person on the streets as well?
That is one of my ex's baby daddies. And I got into it with him in San Pedro Park, and I pulled a pistol on him, and they dropped it to that. I'm new to all this, so I don't really know how to answer the questions really, but
Oh, truthfully,
yeah.
that's how you answer the questions.
Yeah, but I do know him. I don't know his name, but I know we have past history already, and we press charges on him.
All right, State, do you have any idea when you will have the laboratory reports or?
Judge, I'm assuming that it's probably meth, but I haven't read that case yet necessarily, but I believe that it happened on December 5th, if I'm right. It's been a little over a month. It should be another 3 weeks, hopefully. That usually meth comes back pretty quickly within 60 days.
All right. So could you reset this for 60 days, please? And then I'll grant your PR bond.
It'll be March 10th.
All right, and if you could give them a reset form. And I'll waive the bond fees. I'm going to order substance abuse treatment. It will be outpatient. We're going to do random testing. I'll ask that the fees be waived. And I'll add that you are to reside. You're saying Haven for Hope?
Yes, ma'am.
All right, and I'll put in here that he's to reside at Haven for Hope. And if you end up having another place to reside at, before you change that, you will have to get permission from the court. Do you understand?
Yes, ma'am, I do.
So you're going to be doing outpatient treatment. There's going to be random testing, and you're to reside at Haven for Hope. And your next court date is going to be March the 10th. So they're going to give you a reset form. You need to keep that reset form. You understand?
I have one question.
Yes.
Is it gonna be here, the court?
Yes.
Okay.
All right. Is there anything else?
Nothing else, Aaron.
All right. Thank you. Just sign the reset form.
Thank you.
All right, just so everyone is aware, I have a judges meeting at noon. So if we are not done, you will be back here. Yes. That's available. Yes, thank you. All right, Robert Garcia. Who's here for Robert Garcia?
Here for we are.
Have you conferred with the state
I have, Judge.
about the actual case?
Yes, yes.
Okay.
Yeah, I'm sorry, we've been conferring all morning, as a matter of fact.
So Judge, it's a nightmare case, it's unindicted. Whenever I looked on discovery, all we had was the support. I did make an offer to defense based off of that, but defense obviously wants the discovery in this case.
Very good. So you're talking about the PR bond part?
I'm talking about the actual underlying facts of the case. So has the offer been tendered to your client?
Yes, Judge, but it's a for sale offer, but
Well, no, I don't want to know what the offer is.
It's 3 cases, Judge, so we're
Okay.
trying to wrap them all up into one, into the evading. But unfortunately, there's no discovery on the evading right now, so that's for sure recess, so they can get that to you, we can look at it and hopefully come back and knock this out.
All right, so what we'll do then is we're going to reset this and we'll reset the PR bond with the case. We can bring it back next week.
Okay,
And I can try and see, Judge, just it's Somerset Police Department, smaller agency. I just don't know how quickly they're gonna be able to get me that.
All right.
Judge, I think I'm a little confused about the PR bond part. Were we here actually to discuss whether or not he gets a PR bond?
We can do both.
Can you give him a PR bond?
After reviewing this, unless you guys present some other evidence, it appears that I'm going to deny his application.
All right. Well,
Now, I will tell you this, because I don't think Mr. Garcia should just be waiting at the Bexar County Jail. So we can come back next week and the state can see if they have the information for you, but there are things in the PR bond report that the court finds very concerning.
okay. Well, hopefully we'll-
And Judge, I think the reason why we don't have the evidence just yet, I think it's still, he was arrested like 30 days ago.
Okay.
It's a very short turnaround.
Okay.
Just wanting to make sure that you're just aware of just that. I'm gonna try and rush it to get all the evidence, just
Okay.
due to how soon it was.
So you want to call this back in 2 weeks then?
That
And
might
then
be
if you all have it before then you have it before then.
Sounds good, Judge.
All right. So either we'll come back then on the 20. What is this? The 27th. So on Robert Garcia, it's gonna come back on January 27th. All right, thank you.
Thank you, Your Honor. Maybe we-
Yes, you may be excused. Thank you. Who's here? Alejandro Black off docket matter?
That's me, Your Honor.
Yes.
How are you this morning?
Oh, I'm doing great.
Good. How much backstory do you want?
Well, what are you requesting?
I'm requesting to either push it back later in the week or to the next week. It seems like two things happened. I requested a doctor's appointment about 2 months ago online. They didn't notify me of this until about 3 days ago. And so it's 8:30 that same morning. So I'm hoping to avoid that. The other thing is the state and I have had some conversations. It seems like we're moving in a location on the case that might end up working out if the court allows it. So it gives us a little bit of extra time, and it also makes it where I don't have to push another medical appointment to like mid-March, basically.
Oh, no, you can keep your medical appointment, but the problem is your client didn't appear by Zoom.
What do you mean?
Your client was supposed to appear on December 5th and he did not.
I thought you waived his appearance. That's what I told him. So that's my fault if it's anybody's fault.
All right, because it says defendant didn't appear by Zoom. So what I did was he didn't have to appear in court, but he was to appear by Zoom. And on November 7th, when I gave my orders, I said defendant may appear by Zoom.
So I can show you my text history with my client where he goes, do I need to be in court today? And I said, no, you don't. So that is my fault.
Yeah, no, not in court, but by Zoom.
I'm telling you, I misunderstood and it's my fault, not my client's. He was in active communication with me literally on that day. And I said, no, you don't need to be there. I'm there for you. So that's my fault. So
All right,
I'm sure he's sorry. I'm very sorry because now I'm thinking, does my client have a warrant? And I didn't even know that. And that freaks me out.
all right, so you say you can't be on here on the 17th because you have a doctor's appointment?
At 8:30. I don't know how long it's going to take, but
Okay, so then we can recall it on the 18th.
might be a busy morning, but beggars can't be choosers.
Mhm. You know, it's funny you should say that because lately we've getting a lot of people, beggars are being choosers. Like if you see somebody and they don't have a meal and you say, all right, well, I'll give you a meal at Jimmy John's. Well, I don't want that. I want steak and lobster. Well, it's like, no.
Are you able to confirm my client doesn't have a warrant? I just want to make sure he doesn't have a warrant.
No, your client should not have a warrant because it's not written in the docket that I issued a warrant.
Perfect, just making sure.
What's issued on the docket is he didn't appear by Zoom.
Are you able to amend that so you can say that's Colin Hobbs' mistake and he's a doofus? I'm happy to have notes on that.
Yeah,
I mean, you
can
want it to be my client who's.
you can write a letter and I'll put it and you can file it and I'll put it in the file.
Okay, I can do that.
All right, so this is going to be recalled for January 18th.
Thank you, Ron, I appreciate it.
You're welcome.
Y'all heard that, appreciate it.
And on January 18th, council, you need to be here exactly at 9 because on January 18th, that is, well, you know what? Let me change that. Not the 18th. Let me do it for January 19th because the 18th is our jury trial date. So we'll come back on January 19th. All
Understood. Thank you, Judge.
right, thank you.
Appreciate y'all.
You're welcome.
Thanks, sir. Yeah.
And that's on Alejandro Black.
Yeah.
And could I also see the file on Julian Reyes? Hey, it has to be done. I want you to have the knowledge that you need to survive. All right, and Deputy Laura, am I correct? You didn't order Julian Reyes in Belleville, right? All right, because she's not here. All right, so we'll find out what date she's going to be available. All right, so I'll keep those.
Does he have an NPR? I'll tell you to report to him. Yeah.
You give them a second. I mean, it's fair. Yeah, put it back. Yeah.
Yeah, I think so. My fault.
Well.
Sure. All right.
Right now. No one ever updated.
All right, everyone, we'll take up Kyle Adams as soon as the court reporter is back. All right, you ready? We're going to go on the record. Court is calling 2022 CR 11030, State of Texas versus Kyle Adams. Could I have parties announced for the record for the state?
Jason Garrett.
Defense?
Brian Kimbrough.
And are you Mr. Adams?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have it. I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Adams, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you weigh the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Bill, Your Honor, we're waiving the paragraphs and proceeding just on tamper with evidence.
Any objection?
No objection.
Mr. Adams, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of tampering evidence with intent to impair? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Adams, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $2,500 fine. And the state will take in consideration cause number 2022 CR 11029. Did you understand that to be the plea? Defense, is that the plea?
That is, Your Honor.
State, is that the plea? Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. Number one with all this.
No, Judge.
Mr. Adams, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I would ask the court to follow the plea bargain. I also asked the court if it would to run these concurrent with 2 cases that he has. He's on parole. 2017 CR 1611 and 2017 CR 11315.
I'm sorry, 1-1.
315.
All right. Anything else, counsel?
Oh, he's asking you give him his back time that he's been. I know you will.
Yes.
Yes, you have.
Legally, I have to give you credit for any time, sir.
Well, the thing is,
Sure.
because
If your attorney wants you.
All right, go ahead.
well, I had bailed because they had lifted my blue warrant for my parole and I had bailed out. And parole never let me out. And then they said my rearrest date was, so there was like a month and a half to where I was technically not under arrest. So I was still trying to get that counted towards myself.
All right. Well, if your attorney provides that information to the clerks, I always give people credit if they were in time, in custody while a case was pending. You're welcome. All right, just let,
I'll look into it.
all right, the court will follow your agreement, sentence you to 5 years in prison. There's a $2,500 fine. Time and money is to run concurrent. Taking consideration 2022 CR 11029. Credit for any time served. This is run concurrent with 2017 CR 1611, 2017 CR 1135. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you?
35.
All right, so you still have some more of your life in front of you and not so much a lot behind you. You're gonna have to make a decision on who you want to be in this world, right? Do you want to be the guy who's constantly in and out of jail, constantly in and out of prison? If that's your choice, you can make it, but it will be nobody's fault but your own. If there's something that happened to you in your past that caused you to do this, at some point in time, it's no longer other people's fault. It's because of your bad choices. So the decision is up to you. And what you did in that report, taking drugs or ingesting, you never know what drugs are. You never know what they put in them. They're not FDA approved. I've never seen a drug that was made by someone on the street that has a label of ingredients. So do better, okay? All right, good luck to you. You're welcome. Court is calling Jonathan Ramirez, 2022 CR 8755. State of Texas versus Jonathan Ramirez. Could I have the parties approach and announce for the record for the state?
Casey Gary for the state line.
For the defense?
Kathy Compton for Mr. Ramirez.
And are you Mr. Ramirez? Mr. Ramirez, I'm sorry, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery? Did you review that with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Ramirez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, it appears that you're proceeding on the indictment as presented. Is that correct?
That is correct, Your Honor.
All right, Mr. Ramirez, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with criminal mischief, $2,500 to $30,000? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? You can unfold your arms. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely, yes.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
So to say.
I'm sorry?
So to say.
I'm sorry, what?
So to say, yeah, a little bit.
Okay, I don't understand the
Yes,
first.
ma'am.
All right. Do you want a jury trial?
No, no.
Because we'll give you one.
Sure don't.
So again, so we're back to the question, are you satisfied with the way you've been represented? All right, the court will find that defendant has, I'm sorry, now are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the state jail facility. There are no applications. Did you understand that to be the plea? Defense?
Yes.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it?
Yes, ma'am. Sure did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there have not.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Exhibit number 1 with all staff, Your Honor.
No objection.
Mr. Ramirez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, the court is finding there is sufficient evidence to find you guilty and the court is finding you guilty Are you proceeding with sentencing?
Yes, Your Honor.
All right, is there anything you wish to say on behalf of your client?
Your Honor, I would just like to make a brief record if I may.
Yes.
I just want for the record to state for the court that I had discussed this case at length with my client. We met while he was out of custody and went over all of the police report, 911 call, videos, etc. I negotiated the plea to waive 2 previous convictions that he had when he had gone to TDC previously. And while I believe that I've done a great job, I did explain very clearly to him that if he was not satisfied with plea bargain offers, that he certainly could go to trial. He has, as the court's seen, agreed that he wants to take advantage of that plea bargain offer, and I would ask the court to go ahead and follow that and allow him to go ahead and serve the 1-year state jail. But I want to make very clear, and it always concerns me when somebody insinuates that I didn't do my best or didn't do a good job, because you know how hard we work. I know how hard I work. And I just want to make clear that I did everything that I could for this young man standing here before you. And I am asking you to please go ahead and follow that.
All right. And so with his prior trips to prison, then is that something, because I don't have that before me, is that something that would have made this enhanceable?
Correct.
And
To
with
a
the
second-degree felony. Your
2 to
Honor.
20 years.
Correct.
Now, Mr. Ramirez, what I can tell you is I read the police report. And honestly, from reading that, there's so much that could have went wrong. So the fact that you all have agreed to 1 year is to your benefit,
Yes, ma'am. I realize that.
because more is deserved.
I realize that.
And what I can tell you, if the state would have offered 15 years and went forward on the enhancements, I would have said, yeah, 15 years, that's about right. So you're lucky that your attorney was able to negotiate for you and only get 1 year for somebody who's been to prison on an offense that could be enhanced to a 2nd degree.
Yes, ma'am, I know. I'm blessed. I'm sure the wonderful attorney.
Well, then why all this hesitation and this, I don't know, attitude about, yeah, I think she's okay, or whatever you're saying?
I mean, no, it goes deeper than what it is. You know what I'm saying, I mean, I have a 4, 8, and a 12-year-old, and I've been going through emotional stuff personally, but I don't mean no disrespect towards my attorney.
Well, the fact that you have a 4, 8, and 12-year-old and you're going to prison, and you've obviously been in and out of prison while you had those 4, 8, and 12-year-olds on the planet, that's your fault.
Yeah, I know that.
These are bad choices that you are making.
I really know that.
And so if you want to be in your children's life, that is not your attorney's fault. That's all on you for not doing what you're supposed to do. You're not stepping up to the plate and being a father they can look up to. And this whole thing, this whole police report where you're chasing somebody in a vehicle, guess what? When somebody doesn't want you anymore, they don't want you anymore. Relationship is over. Move on. And all of these relationships that people are in.
Somebody that he had, this
I
was
know.
a stranger.
I know. But all of these relationships that people are in with spouses, with girlfriends, with boyfriends, you have known your parents longer than you've known these people. These people come into your life for a year or 2 years and you act like you can't live without them. So here's the thing. You have children on the planet. If you're not going to be a good father to them, if you're going to be in and out of the prison, it's probably best that you cut them loose so that perhaps they can have a good start in life without you in it and bringing nonsense. I'm going to follow your agreement. I'm going to sentence you to 1 year in the state jail facility, give you credit for any time served. And I was tempted not to give you any credit, which I could do for that.
Did check, Judge, and he has calendar days, 191 days. And I'm so sorry to derail you, but
No.
it does, I take it personally when somebody acts like I didn't do my best, and I just.
And the court is aware of your work,
Thank you.
and the court appreciates your work.
I appreciate that.
And she also speaks Spanish. And Jason, I appreciate your work too. I don't want people to say I'm unfair.
I worked with Jason today, but I'll appreciate him later.
All right. It's there. I appreciate Jason Garahan. I appreciate Kathy Compton. I feel like Romper Room. I know I'm aging myself with Romper Room where she would look through the mirror. And Michael Villarreal, I appreciate you as well. Thank you. And everyone else who's in the room. All right, Mr. Ramirez, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Do better, okay?
Thank you.
You're welcome. Thank you. Court is calling 2022 CR 10021, State of Texas versus Emmanuel Saldana. Can I have parties announced for the record for the state?
Jason, do you have the state law?
For the defense?
The attorney record is Joanne de Hoyos. Joseph states in covering to Mr. Hoyos and Mr. Saldana. Would you give this court permission for me to do the plea in place of Mr. Hoyos?
All right. Oh, and if you could keep your hand off the microphone, you've turned it off. Just press the button. Thank you. It's always a pleasure to see you, Mr. Statson. Mr. Statson, we're off the record. Mr. Statson is becoming like Mr. Cox and Mr. Navy. We need to have them a back office in the back. So we have an office in the back for you guys. All right. We're back on the record. Mr. Saldana, I'm showing you what, I'm sorry, Mr. Statson, I'm showing you the discovery acknowledgement. How you received all the discovery in this case and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Saldana, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney?
Yes,
Did
sir.
you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, and I noticed that in the paperwork, it probably does not say that.
Yeah.
So we are proceeding on count 1 and count 2, and they're both harassment of public servant.
Mr. Garahan, I'm sorry, sir, can you speak up just a little bit?
Yeah, sure.
Can you say that again?
Yes, we're proceeding on count 1 and 2. It's not in the paperwork, written in the paperwork. We are continuing on both of those, Your Honor. And they're both harassment of a public servant, felony third.
All right. And Mr. Saldana, you understand that the state is proceeding on both counts?
Yes, ma'am.
Defense, are you aware that they're proceeding on both counts?
Yes, Judge.
All right. Mr. Saldana, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yeah.
Did you understand in count 1 and count 2, you're charged with the offense of harassment of a public servant? That is a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, off the record for a moment. So everyone in the box, excuse me, we're on the record. It makes the court reporter's job easier if you all don't talk in the box while we're on the record. We're back on the record. Did you understand the range of punishment for that is anywhere from 2 to 10 years with the possible fine up to $10,000? If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea, gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter in a plea?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, and a judge, a doctor did find him.
Mr. Saldana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yeah.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney?
Yes.
Did you understand it? Did you sign it in all the appropriate places?
Yes.
According to the plea bargain agreement, punishments be assessed at 3 years in the prison and there are no applications. Did you understand?
Yes.
State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah.
Counsel, are there been any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
Count two, how do you plead? Guilty, not guilty, no contest? State any evidence to support the plea?
Yes, Your Honor. State office is in the form of all this attachment, Your Honor.
Defense has no objection.
Mrs. Saldana, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yeah.
Did you understand by entering this plea that means the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. The court has reviewed the same. The court is finding there is sufficient evidence to find you guilty, and the court will find you guilty of count 1 and count 2. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I just ask that you follow the plea bargaining agreement.
All right, the court will sentence you to 3 years in count 1, 3 years in count 2. Count 1 and count 2 will run concurrent, and the court will give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, good luck to you. We can go off the record. People don't like to be spit on. Okay? All right, and if there's some other issues going on, you got to take care of them, okay? All right, good luck to you.
Thank you.
You too. Thank you. Who's here on Juan Montoya? Michael Juan Montoya. All right. So on this one, the state was to make an offer. Were you prepared to make an offer or no?
We made a tentative offer, but it's a tentative offer, Your Honor. I conferred with Mr. Allen and preferred that offer. But I believe it's not, I believe he's also waiting on an expert of his to give him back a report.
Yes, Your Honor, that's correct. Part of it is our responsibility as well. There was a tentative offer made, but I believe that there are things out there that will help bridge the gap and possibly reach an agreement at some point.
All right, how long till your expert's report is prepared?
He told me he was gonna get it to me by today, so I would hope by the end of today.
All right, can I have a 30-day reset?
Yes, that's February. February.
All right, we're going to come back on February 10th, state. At that time, if you want to make a different offer, of course, you all are more than welcome to continue to negotiate, but I'm going to expect an offer on that day. And then Mr. Montoya, I'll give you a plea deadline date. Do you all have all the discovery?
We do, Your Honor. I believe we have an acknowledgement file.
Yes. All right, thank you.
Thank you, Judge.
Yes. Oh, sure. Oh, no. Okay, thanks. Who's here on Guillermo Rodriguez?
Good morning, Your Honor.
Good morning. So what's happening with this case?
State is asking for time to reach out to the complainant before they can make an offer. This is our first setting.
No, actually, it's a third setting.
Third setting?
Mm-hmm.
This would be the fourth.
Yeah, that's okay. All right, state, how much time do you need?
Judge, just a little bit of time. We have a phone number. It's just someone that lives nearby. So they should be willing to pick up.
All right, on Guillermo Rodriguez, can I have a 3-week reset? Is that enough time? Okay.
I've already asked her.
Okay, thanks.
It'll be February 3rd.
All right, so we'll be back on February 3rd. All right, thank you.
Thank you, Judge.
Excuse me, on Julian Reyes, can you reset that for 3 weeks as well? He's in custody. And, oh, you're here on Julian Reyes?
And I do want to chat with him, maybe it will.
Okay, all right, thank you. I didn't know you were on this case.
Well, he has two lawyers. I'm on one and Judge Christian's on the other in the list.
Okay, all right, thank you. Okay, all right, thank you. Oh, he's not here.
Oh, he's not here.
No, because we can recall it for next week.
Okay.
All right, so on Reyes, can you recall that for next week? And if we could recall it, Mr. Toshi, are you available on a Thursday?
Let me check real quick, Judge, if that's okay. I will be around. I'm not.
All right, we can do it either Thursday or Tuesday morning.
I know that I have an out of setting in Frio, out of county in Frio, but let me confirm the day.
All right,
Next week.
all right. Then on Malik Belalu, can I have a 3-week reset for that?
Judge, is it okay to do that on Fridays, or do you want to do?
Friday is fine.
Okay, so then it'll be the 3rd.
Okay, thank you.
You're welcome. Sorry, what was the last one that you asked me for? What was it?
It's BEAULIEU.
Oh, okay. Thank you.
Benny Santos. Come down.
Yes, sir.
So we're here for discovery.
Yes, ma'am.
All right, where are we on discovery? Yes.
So, we have the CPX record, we need to turn over once court signs up.
Okay.
And then absent that, I believe that you just needs to review. I don't know if he's coming yet to review the child safe.
Okay.
There's 2 videos.
There's DVDs, Your Honor. Yes.
All right. So how much time do you need? 30 days?
Yes, Your Honor. I've only been on the case about 90 days, and today I'm getting this, these discs to review, and then I'll need to meet with Michael about that.
All right. So on this, because there's disc, and I know you have to make arrangements for the child safe, I'll give you a 40-day reset.
Thank you, Your Honor. I appreciate it.
And then you all can confer off Docket and Mr. Santos. If they want you to come back sooner than the 40 days, your attorney can always request that, okay? All right, can I have a 40-day reset on Benny Santos?
Yes, sure. One second.
And Mr. Santos has asked me to ask for a bond reduction. I've advised him that the court's custom is to refer that to another.
Yes, it will go to Miguel Nahara.
In fact, that's what I told him.
All right, thanks.
I even pronounced his name correctly as you.
Oh, awesome.
It'll be Monday, February.
All right, so we'll be back on February 20th.
Thank you, Your Honor. May I
You're
be
welcome.
excused?
Yes.
Oh.
Who's here on Yvonne Pettis? And where is Yvonne Pettis?
Oh,
All right. So what is happening with this case?
Judge, I've conferred with the state. We're still missing, I think, quite a bit of discovery on the case. This is a child theft case, Judge. So
Okay.
It's, I looked today and there's already, the index is 33 pages and we are still missing autopsy, University Hospital records. There's a bunch.
All right, on Ms. Pettis, can I have a 60-day reset, please? Which everyone will tell you I normally never do.
This is a unicorn.
Yes. All right, and so, Mr. Allen, if you want to brought back sooner than 60 days, of course, you can always request that.
Thank you, Your Honor.
It'll be March 10th.
All right, we'll be back on March 10th.
Thank you, Judge.
You're welcome. Who's here on Michael Christopher Lucio or Lucio? Lucio. I pronounce it two different ways and they're all wrong. See, I was trying to do the French thing. The Italian thing. Court is calling 2022 CR 10887, State of Texas versus Michael Lucio. Could I have parties announced for the record for the state? Defense?
Leslie Sahanovich on behalf of the defense.
And are you Mr. Lucio? How do you pronounce your last name? Lucio. All right, I've pronounced it 4 times wrong. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lucio, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I'll give you, Your Honor.
All right, off the record. So attorneys, trial court certifications, don't fill those out with the check marks because sometimes people put the wrong check marks down.
Okay.
So just
Thank you.
sign it. Yeah. And it's just not for you, Mr. Sakawanowicz. It's for everybody.
I understand.
All right, Mr. Lucio, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with assault on a public servant as a 3rd-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Lucio, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,500 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes,
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No motion, Your Honor.
Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest? All right, off the record for a moment. Caroline. They've given me the paperwork on Griffin, so I've signed it. All right, Mr. Pettis, I'm going to send you back to the breakout room. A clerk will be in there shortly to swear your client in.
Thank you.
And Mr. Simmons, is there a reason you're by Zoom?
Yes, Your Honor. I have Mrs. Alonso. She was on the docket for yesterday, but she was told to come back in via Zoom at noon today, Judge.
Okay, all right, thank you. I'll put you in the waiting area and we'll see if she shows up.
Yes, Judge.
Thank you. All right, we're back on the record. Showing you outside the agreement. State is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations by the state and the court does not have to follow those recommendations?
No.
And I'm sorry, then to the offenses charged, how do you plead guilty, not guilty, or no contest? State any evidence?
It's exhibit number 1 and all of its attachments.
No objections.
Mr. Lucio, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Just one other caveat on the, we conferred after that, we submitted the paperwork that we're trying to do is run this deferred adjudication concurrent with a TYC, juvenile.
Okay, we'll get to that. Let me see if there's enough evidence first.
Thank you so much.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we'll wait. Yes,
Anything you wish to say on behalf of your client?
yes, Your Honor, one more thing, one more caveat. He is, he has, he was, or juvenile, court number, which I tried to get, but they wouldn't reveal to me because not concerning the record for that one case. But I confirmed with the state and our word, in agreement to run its, this for concurrent with whatever, whatever community supervision or concurrent with that case number in the juvenile case.
Okay, my understanding, unless the laws have changed, usually when you have a juvenile who has a juvenile case and then they become an adult and they pick up an adult case, usually they do away with the juvenile case. So somebody should check on that.
My understanding is that in the juvenile case, he's been sentenced to 6 to 12 months at TYC. And so that's what he tells me. And that's what he's telling me, but I can't get any information because I'm not the attorney of record.
All right, is the juvenile case somehow related to this case?
He was at the juvenile facility.
Well, I mean, I know he was at the juvenile facility when this was committed.
Right.
All right, so has anybody talked to a prosecutor on the juvenile side?
I have not, because I just got her name just a couple of minutes ago, Judge. The district clerk's office will not give me any information.
Oh, no, I mean, they won't about juvenile cases. So do we know who the juvenile prosecutor is?
Somebody by the name of Ellen, maybe Wheeler?
All right, does anybody have any contact information for her? So,
I can pull up with the assistant judge. I don't have a personal phone.
all right, is anyone able to email her?
Email her, Your Honor.
All right, so just give us a moment on this sentencing. Let's see about that. Who's here on Fabian Vega? All right, so what are we here for?
It's a discovery hearing, Your Honor. We had requested discovery from the state that was outstanding, and we have, and we received it all, Your Honor. Just
Okay.
Yeah, Judge, I gave defense 38 discs. It's for both the aggravated assault, deadly weapon, and for the murder charge.
Mhm.
Defense did bring up an interview that they wanted to see, and I did show that that was one of the discs that was prepared.
That's correct. That's correct, Your Honor.
All right, so I'll note on the file that all discovery is received and we'll be back here for jury trial on February 21st.
Yes, Your Honor.
All right, and again, they'll bring you over dressed for trial, but trial in whatever the clothing you have. If you wish to wear something different than what you have at the jail, then you need to make arrangements with your attorney for a clothing exchange. Okay, all right, thank you.
Yeah.
Sure.
30 seats. It's quite a hefty-
Hey, I hear you. Wow.
I had the pleasure of looking at it.
5 hours, but see, you know, what? It's still not 13 hours.
All right.
I can, you know,
And I have a judges meeting at 12, so I'm going to take up this plea that they're doing on Griffin. And then after that, other people, you have to come back. I'm sorry. I'm throwing everybody off because I have a judges meeting. No. Oh, they wrote them down. Oh, we haven't done a date yet for him. Because he should have been, we should have still brought him over because I see Toshi as the other person on that case. Well, y'all don't have Reyes, right? Yeah. Deputy Laura, let me ask you, is it possible to have him brought over later today, or is that not possible? Or are we able to do it by Zoom? Oh, can you call over and see if we can have it done by Zoom? And Ms. Ferguson, if you'll get Mr. Toshi back here.
Those are Mr. Toshi's clients.
Okay.
He's right there.
All right, Mr. Toshi, they're telling me that Mr. Reyes, they'll be able to get him here by Zoom. If you're okay with that.
Just do it Thursday, because this family's not that his family matters, but because I'm working on a plea with Mr. DeLoma, and then I still have one more that I need to confer on, so. I'm chasing my tail. Yeah, Thursday's a good day normally.
Okay.
It is.
All right, thank you. Oh, no, I appreciate that. Thank you.
Judge.
Is there a different?
I was sent that to the defense.
Okay.
Yes. Because I guess he doesn't have access.
Hi, Estrada, this is Mama, the coordinator for the 187. Do you have the inmate by the name of Griffin on Zoom? He should be on Zoom. He doesn't have access to the mouse and he needs to sign his consent form. Can someone go help him? Okay, thank you. Bye-bye.
Okay. Okay, so I'm sorry.
What do we have? And it could be a training to me some part.
All right. You can send them back. Ms. Ferguson, where is Bob Hicks and Ray Adams? Yes. All right, Mr. Lucio, if you'll come back down. All right, so we are back on the record in 2022 CR 10887. State of Texas versus Michael Lucio. So does anyone have an update from the juvenile prosecutor?
Yes, Your Honor. I spoke with her on the phone. She gave the case does not go away. He was committed to an indefinite term. I thought it was 6 to 12 months.
Okay.
And then also she gave me the juvenile case number.
Okay, what is the juvenile case number?
The juvenile case number is 2022 JUV 00840A.
And do you all still wish to continue with the plea as it has been bargained for, knowing that you have the new information about the indeterminate sentencing? Okay. All right. Mr. Lucio, how far did you go in school?
Doing 11th grades.
Where are your parents involved in your life?
No.
So where are they?
I mean, I have conversation with my pops, but I'm in CPS, so it's like kind of like joint custody.
Okay. So are you still in CPS care?
Yes, ma'am.
So what are you planning on doing with the rest of your life?
Hopefully turning around and going to school.
So what happened with this case? Why were you getting into a fight with a guard?
I was already sentenced to like to the JD, and then I kind of just started going off. I mean, I didn't think it really mattered whether I just did not. Regarding the pressing charges, I came here and I've been sitting here for like 5 months. While being here, I mean, I started my GED. I'm supposed to be taking my GED test, but I need confirmation from my judge, my parents, and I think somebody else. I'm not too sure.
Well, that'll be your caseworker, because technically, when you're in foster care, your caseworkers are placed in the position of your parents in a way. All right, this is what the court is going to do. Court is going to sentence you to a $2,500 fine. That will be probated. 4 years deferred adjudication. Do you have a place to stay when you're released?
Yes, ma'am.
Who you'll be staying with?
My father's house.
That's not a good place. And let me just tell you why that's not a good place. That's not a good place because Child Protective Services is involved.
Like Child Protective Services took my rights away from my mom. My pops ended up getting my rights, but since I'm like constantly locked up in and out, they gave like.
And his father did call me on his behalf before a court judge, and yeah, I've spoken to him at least 2 or 3 times.
What's your father's name?
Daniel Lucio.
And does he have any criminal charges previously?
Not that I know.
Any drug use?
Not that I know.
All right, this is what the court is going to do. Court is going to sentence you to 4 years deferred adjudication. There's 220 hours community service restitution hours. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 of those hours will be waived. I'm going to require that you get your GED, or either you're going to be in some sort of trade school and get a certificate for that. Once you've done that, the court will waive the remaining of your community service hours. You're to reside with Daniel Lucio if probation determines it's appropriate. Do you have any children?
No.
All right, that's a good thing.
That's what I told him too.
All right, there's to be regular reporting by Zoom or in person. I'm going to give you a curfew upon release of 6:30 p.m. We're going to do GPS, waive fees, defer fees. I'm going to want field visits 2 times per month until further notice. And there's to be anger management. And we're going to do regular UAs. Probation is, this is to run concurrent with 2022 JUV 00840A. Probation, is there anything else he needs? Is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. You're gonna have to start making better decisions in your life. You understand? All right, good luck.
Thank you.
You're welcome. All right, after I do this other plea, I need to take a break. Yes. 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 Okay. Oh, is that something I need to sign?
This one.
All right, thank you. Oh, yeah, no problem. You are. You're welcome. All right, thank you. All right, the court is going to call Court is calling 2022 CR 3797 State of Texas versus Xavier Griffin. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Adrian Bettis for the defendant.
And are you Mr. Griffin? You need to unmute.
Yes, ma'am.
All right, we're proceeding by video. Any objection from the state?
No, Judge.
Any objection from the defense?
No, Your Honor.
Mr. Griffin, I'm showing you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Do you understand that you have a right to appear in person if you so choose? Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
And have you received all the discovery in this case?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Griffin, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
I don't think we got.
We're going to discard that one, Your Honor. We're going to be pleading to time on the state jail. And Carolina said she'll make any corrections to the case number. We just need to discard that paper.
All right, thank you. All right, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Griffin, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with evading arrest, detention, 2 or more as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow that agreement. If for any reason the court does not follow that agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
I did.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Griffin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has
No, ma'am.
anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
I'm sorry?
I am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishments be assessed at 9 months in the state jail facility. There are no applications. They're taken in consideration 2022 CR 3796, and you agree to forfeit any firearms. Did you understand that to be the plea?
You said taking in, what are they taking into agreement?
That's the case they're going to dismiss.
Consideration 2022 CR 3796. Did you understand that to be the plea?
I did.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Offer State Exhibit 1 in all attachments.
No objections, Your Honor.
Mr. Griffin, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Court will sentence you to 9 months in the state jail facility, give you credit for any time served. Take in consideration 2022 CR 3796 and you to forfeit the firearm. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Griffin, good luck to you. Do better, okay?
Yes, ma'am.
All right, bye-bye.
Bye.
Thank you, Mr. Pettis.
Thank you, Your Honor. I appreciate you allowing me to appear by Zoom. Have a great day.
You're welcome.
Bye-bye.
Bye-bye. Court is calling 2022. Where's James Toshi?
Am I good to go?
2022. Yes, you're free to go.
Thank you, Judge.
But don't leave. Let the deputy come pick you up.
Of course.
Thank you. Court is calling 2022 CR 7467, State of Texas versus Eric DeLumbo. Could I have parties announced for the record for the state? Defense?
Mr. DeLumbo.
Are you Mr. DeLumbo? Counsel, I'm showing you the discovery acknowledgement and your client needs to be in the middle. Have you received all the discovery in this case and did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. DeLumbo, showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, we will proceed on count 1 and waive the remaining counts. We are also waiving the enhancement.
Any objection?
No, ma'am.
Mr. DeLumba, I'm showing you what's entitled court's admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged in count 1 with the offense of possession of a controlled substance with intent to deliver, penalty group 1, 4 grams to 200 grams? I'm sorry, I need that trial court certification. This is a post offer, correct? Okay, sorry. Did you understand that the range of punishment for that offense is anywhere from 5 to 99 years or life and up to a $10,000 fine? Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial? Thank you. A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. DeLumba, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, you're proceeding on count 1. Punishments be assessed at a cap of 15 years in the prison. State opposes your application. They're taking in consideration 2022 CR 8371, and there's to be no contact with Natalie Rodriguez. Did you understand that to be the plea? Defense, is that the plea? State, is that the plea?
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No.
To count one, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Your Honor, we have the state's exhibit number 1 and all.
No objection, Judge.
Mr. DeLombo, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Counsel, will you be requesting a CHOP evaluation?
Yes, Judge.
All right, so we're going to come back on February 10th. I'm going to request the PSI and the TAP evaluation. When you come back on February 10th, I will make a decision on your application based upon the PSI report and any other evidence that's presented to me. All right, thank you. Yes. Okay, she's saying that, okay. Okay. All right. And after that, the court is going to. Okay.
One of the cases that was about yesterday.
All right, thank you. Thank you. All right, everyone, we're going to take our break. And I'm so sorry. I know I said that we would not come back in the afternoon, but I have a judges meeting that was unanticipated. So we'll be back at 1:30. I think, isn't there some, is CTD needed? Norma, is CTD?
One second. Let me, I can go over and I can let them know that you can leave your meeting, judge, and I can review it. I got Caroline's docket and I can
Okay.
check real quick.
Awesome. And then, Mr. Toshi, what is happening with Duran?
Judge, we're still conferring. We're at an impasse right now. So I don't know what to tell you about it than that.
Could I see the file on Duran? Okay. Okay. Oh.
Oh, it is? Well, never mind.
All right. Is that Duran in the box?
It is, Judge, and just so you know, I think that Ms. Mitchell is becoming familiar with his case, and her and I are just kind of picking up a fresh dialogue, and so.
All right, Mr. Duran, if you can come forward. All right, so Mr. Duran, I'm going to give this case one more reset for plea deadline date. And that's so that the state and the defense can confer, and so that your attorney can confer with this prosecutor, okay? And defense, if you want to come back sooner, you're more than welcome to come back sooner. All right, Ms. Ferguson, can I have a regular reset on Daniel Duran?
I can do February 10th.
All right, so we're going to be back on February 10th.
And Judge, the only thing I see is Bob Hicks' case and Ray Adams' case. Ray Adams said he can be here at 1:30.
Okay. And who is Ray Adams? Is that criminal trial division or family violence?
Criminal trial division.
Are you able to come back or no? All right.
It's an NPR, he has two, yeah, the family violence, case in,
Oh, that's all right.
Missouri,
We'll be back.
Okay.
and criminal trial division. Case, and then NPR.
All right. And then Mr. Simmons, on your case, we're gonna have to come back in the afternoon.
Okay, Judge.
Marciela, I'm sorry, what, Mr. Simmons?
If I could get a phone number for Mrs. Alonso, we just got an offer tendered to us, so I still need to convey that to her. And that's what we will be doing today, because I
All
haven't
right, so
spoken.
what I'm gonna do is I'm going to stop live stream and you all can confer and she can